Okay, right. Well, hello there, everybody. And my name is Malcolm Johnson. Sorry for our slightly late start. Computer seems to be going very slow at the moment. But here we are with another seminar. Now, our seminar today is about care leavers' rights. So I gave this seminar last time about 2 years ago. Now, in that time, not really much has changed in relation to care leavers' rights. The basic structure of how care leavers work is very much the same as it always was, um, but there have been some changes. One of the changes, which is really quite important, is that homeless care leavers are now treated much more favourably, and we'll be looking at the precise legislation on that. And recently, at the surgeries that I hold, we have had people inquiring about care leavers' rights in relation to their housing situation. So we will be looking at legislation which is just about to come into force, which will improve care leavers' status in relation to housing quite dramatically. Um, so we will be looking at that. But other than that, the basic structure has not really changed at all. There was a move to make being a care leaver a protected characteristic. So rather like having a sort of being part of an ethnic minority or something like that. But the government said, no, we're not going to do that. Having said that, however, local authorities adopt their own policy towards care leavers. So when you're dealing with a care leaver case, it's always important not just to look at the general legislation, which we'll be talking about today, but to also ask the question, what does this local authority say about care leavers? What is their particular policy? And that could be their policy in relation to, it could be education, it could be therapy, it could be housing, could be a whole number of things. So it's very important to consider whether a particular individual local authority has a particular policy towards care leavers, because some are more generous than others. Okay, so what we're going to do is this seminar is really designed for people who, for want of a better word, don't really know anything about care leavers' rights. It's designed as a sort of easy guide to give you some idea about how it works right from the basics. And for those who are familiar with care leavers' rights, I apologize, but essentially that is the general idea behind this, to give you an idea about where you can look if you need help and how the basic structure works, because it can get quite complex. Okay, so Amika, could we have the next slide, please? Okay, so what we're going to do is we're going to talk about um, terminology and statutes, basically. So the government's always realised. I mean, we've had legislation in place for some considerable time to make local authorities try to promote the rights of care leavers, because they are seen particularly in a vulnerable. They are seen as particularly vulnerable, basically. Um, The legislation or the guidance is obviously in the Children Act 1989. You have a whole series of sections which talk about rights, but the best place to look is really in volume 2 and also volume 3 of the Children Act 1989, because that talks about care planning and the rights of care leavers. So let me just have a quick look at that. Yes, sorry, yes, volumes 2, but particularly volumes 3, which talks about care leavers. So that guidance basically puts in plain English, these are what their rights are. And in the notes that we've prepared for you, which you can have on request, we give you the links. There's also something called the Independent Review of Children's Social Care, which came out in 2022. Now, that made a number of recommendations for changing. That was the review that said that being a care leaver should be a protected characteristic, basically. And apparently, over 90 councils have actually pledged to recognise care experience as a protected characteristic. So that means that you cannot discriminate against a care leaver by reason of the fact that they are a care leaver. So that's why it's so important to check, well, what does this particular local authority recognise as being a care leaver? Now, in February of 2025, the Local Government Association published a good practice guide. And again, the link is in the records. And that effectively tells local authorities, it's guidance only, it's not mandatory, but it's very important. But it tells local authorities what they should be doing with care leavers. So if you want a good update on the way in which local authorities should support a care leaver, that is the guidance to read. So it's quite recent as well. The actual benefits and the actual support they get is very substantial indeed, which is why if you miss out on those benefits, you can lose out quite substantially, not just financially, but in terms of support. So it's very important that care leavers are able to access that support and know what it is. Let's just have a quick word about terminology just to explain that. So when we talk about children, we mean children under the age of 18. And when we talk about young people, we mean young people over the age of 18. Sometimes local authorities will use a name, or you'll see it in guidance, young people, children, but legally speaking, you are a child until the age of 18. Statutes, statutory instruments, and case law. So primary legislation, what we call primary legislation, black letter law, is contained in statutes. The government also publishes statutory legislation, or rather regulations, or statutory instruments as they're known, which is a secondary type of legislation, but it is binding as well. So if it's in a statute or it's in a regulation, it's going to be binding, it's mandatory, you have to do that. If it's in guidance, a local authority probably has to do it, but there might be some discretion there. The problem is for people trying to understand the law is that the plain English, the English that you can actually understand, is contained in the guidance rather than in the statutes and regulations. We've tried to make it easy for you here, but that is why guidance is so important. But in my experience, when you're arguing, really you need to look at the guidance. You need to get your hands on the right guidance, say, look, this is what the guidance says. This is drawn from the statute and the statutory instruments. This is what you should be doing for this particular young person or child, basically. Okay, could we have a next slide, please, Amika? So the Children Act, that is still effectively the main act. It's been amended by several statutes over the years, but every time they amend it, they simply tag on another section, or instead of calling something Section A, they'll call it Section AA or Section AB, and they carry on like that. So I think I saw one the other day, which is now 22CZA, and I think it's got another A on the end of it. It looks confusing, but rest assured, there is guidance that follows this. But we do refer to the original sections here, just to give you an idea of where the original law is contained. But it's the Children Act that contains all of these rules in relation to care leavers, and it's accompanied by volumes 1 to 5. And the important ones for us is, of course, volumes 2, which is about planning, and volume 3, which is transition to adulthood for care leavers. So those are the ones to read if you want to see what the law actually says. Next slide, please. Now, in order to understand what a care leaver is, you've got to understand what is a child in need and what is a looked after child, basically, because that is absolutely crucial in understanding whether a child is going to be a care leaver or not. So what's a child in need? Well, a child in need is defined in Section 17 of the 1989 Act as one who's unlikely to achieve or maintain or have the opportunity of maintaining a reasonable standard of health or development. It's effectively somebody who is seen by the local authority, it's very wide indeed, as somebody who is going to be in need of help. So that's fairly straightforward. Could we have a next slide, please, Amika? So there's a definition of a child in need. Could we have a next slide, Amika? So what does a local authority have to do to a child in need? So a local authority covers a geographical area. Every child within that area, it will owe a duty to, but it then has to isolate and identify those children who are in need. And their duty is to safeguard and promote their welfare. So that's fairly easy to understand, provide them with a range of services. So it's very wide. So that's children in need. We now come under looked after children. What are they? Next slide, please, Amika. Sorry, the slide after that. I think I've jumped ahead of myself. A looked after child is basically a child in care. So that's in the care of a local authority, provided with accommodation. There's a care order in place, could be a Section 20 order, could have been an emergency order, but effectively they are in care. But they don't include children who are being helped under Section 17, which is children in need. So you have two different types of children, and the legal distinction is very important indeed. So next slide, please. How does a child become looked after? How does a child come into care? Well, there's several ways that you can see that. You've got the formal care order, you've got an accommodation order, which is something that could be entered into in agreement with parents. You've got an emergency protection order, and then you've got children who are actually on remand, so they've been charged with a crime, basically. And they're held in some kind of placement. Now, these are looked after children, basically. Next slide, please, Amika. Section 20, we just need to talk about that and what it means. So a lot of children will come into care under a formal care order, and there's a procedure for that. Section 20 is a somewhat quicker way of getting children into care. So you don't actually have to go off to court, prepare statements, basically. It's an easier way of doing it. Unsurprisingly, local authorities try to use it, but you can't use it unless you've got no parents, no one with parental responsibility. So there's no one around to look after you. You're lost or you've been abandoned, basically. And the person caring for you has been prevented from caring for you, basically. So you can use this, and the idea is that you don't have to take out lengthy care proceedings. Now, what some local authorities have been criticised and actually sued for is taking children into care under Section 20 in circumstances where they've got the agreement of the parent, but the parent doesn't really understand what's going on, or the child is then left in care for a very long time. And what the case law says is that they're not meant to do that. But the net result is the same. Once you're in care under Section 20, whether you're under care under a care order, from the point of view of being a care leaver, you are in care, you are a looked after child. That's why it's important. Could we have the next slide, please, Amika? The reason why Section 20 basically is important is because it relates to what happens when a child turns up in front of social services and says, I am homeless. Now, some years ago, it used to be the case that children would turn up in front of social services and social services would say, we are not interested, you are off to our housing department, and they will decide whether they are going to house you. So this was happening to quite a lot of 16 or 17-year-olds. Now, this was challenged in the courts. And the case where it was challenged was a case called RG versus Southwark, and that was in 2009. And basically what the House of Lords said in that particular case, House of Lords is now the UK Supreme Court. House of Lords said that where a 16 or 17-year-old is owed duties under Section 20, this takes precedence over the duties in the 1996 Act in providing for children in need who require accommodation, basically. So what it says is that you can't just shunt children off to the local housing department. They've got to be looked at, first of all, by children's services as a child in need who may need to be looked after. And that might be a formal care order, or it could be under Section 20. But that's the gist behind that. They can't just be shunted off to housing department. Now, there is now a guidance document, which again is in the notes, which tells local authorities effectively what the effect of the Southwark judgment is. So it tells local authorities. So if you have a young person who comes to you who is homeless, basically, and a local authority has said, well, you know, we're going to have to see whether we can house you. You need to look very carefully about whether they followed the guidance, which is in that guidance document. That's the point there. Okay, could I have a next slide, please? So on that next slide, you can see the link to the present guidance that's used in this situation. Could I have slide 12, please? The next slide, Amika. Now, there are a number of cases where people who have never been in care have gone to the local authority and they've said, well, you should have taken me into care. And of course, because they weren't taken into care, that means that they've lost out on all their care leaver rights. Now, is it possible to challenge? Well, yes, there are 3 cases that say that it is. And these are cases brought by something called judicial review. Judicial review is very difficult. You need to go to a specialist solicitor. The time limit is very tight indeed as well. But essentially, it's a way of challenging a public authority and saying to that public authority, what you did was wrong. You didn't comply with the law. You now have to comply with the law. You have to assume that that person had been taken into care and you have to give them full rights as a care leaver. So there's 3 cases there, Southwark, Sutton and Nottinghamshire. But the case that we'll look at, I'll just read it out for you, is Southwark. And that was a social worker arranged for a child to live with a woman who had been her natural father's partner. And now that was a private fostering arrangement, which is perfectly legal. You can have private fostering arrangements. They're catered for under the Children Act. But the problem is that the social worker had, however, prevented the father from taking the child home from school, had taken the lead in making the arrangements and had told the woman that financial arrangements would be made for her. So the court said, well, that's not a private foster care arrangement. That child's looked after. It was not difficult to conclude that the local authority had in fact been discharging her duties under Section 20 of the Children Act 1989, and so the child was looked after. So where you have somebody who's saying, I went to social services at the age of 15 or 16 or 17 or whatever it might be, and I could have been taken into care, but they simply shunted me off to some other department or said, well, no, we can't really help you. There may be an argument to the effect that that person should have been taken into care. Now, if you think that that's the case, best way forward is to make sure you refer them to a solicitor who can look at it. I've seen local authorities actually decide that people should have been taken into care and award them care leaver rights. So all of a sudden they are supported. Simply after one single letter of claim, they will simply look at it and they will accept that in fact that person should have been taken into care, at which point they become entitled to those rights. So that's essentially what those 3 cases say. Could I have the next slide, please? So we've looked at children in need. We've looked after children. In order to become a care leaver, you've got to be a looked after child. You can become a looked after child retrospectively if you should have been taken into care earlier in your childhood. So that's certainly possible. However, we now come to categories of care leaver because it's important to understand this. Now, this is when it gets slightly complex, but just bear with me for the time being. You've got an eligible child, you've got a relevant child, you've got a former relevant child, and then a qualifying child. Now, could I have the next slide, please, Mika? On this slide, you can see there's a number of questions that you can ask, which will help you establish whether somebody is a care leaver or not, or is entitled to care leaver rights. Now, Quorum Voice, I think, actually have a sort of AI tool which you can use on their website, which will actually tell you whether somebody has those rights. But these questions here are designed to elicit information to see whether that person is, in fact, a care leaver or not. So you've got those questions there. So let's first of all look at what an eligible child is. Could I have the next slide, please, Amika? So an eligible child, this is somebody who's on the way to becoming a care leaver, is somebody who's age 16 or 17, and they are still in care, and they have been in care for at least 13 weeks since their 14th birthday, or several periods. So you might have been in periods of, say, 2 weeks, 4 weeks, or whatever. They don't have to be consecutive, but they must amount to 13 weeks. That is essentially the test. You might say, well, that's somewhat arbitrary, but effectively that is the test for becoming a care leaver. So it's designed for people who are taken into care since their 14th birthday, basically, and then they are aged at least 16 or 17. So that's what an eligible child is. That's the first test. Could I have the next slide, please? Now, a relevant child is somebody who's no longer looked after by any local authority, basically, but they were when they were, but they were an eligible child. So they fit that first definition, basically, when they were last looked after, and they are aged 16 or 17. That's an eligible. That's an eligible child. Could I have the next slide, please? Now, what is a former relevant child? Now, a former relevant child is an adult. Now, an adult is somebody of 18 or over. So they are children, sorry, they are adults, basically, but they used to be a relevant child. So you go from being an eligible child, which is your first route to being care leaver. You then go to relevant child, 16 or 17, and then you go to former relevant child, which means that you are 18 or over, but you were a relevant child and you were an eligible child. So you have to sort of build the steps before you get there, because what the legislation does is it refers to all of these terms, and certain people or certain terms are entitled to certain types of support. Okay. We then have, could I have the next slide? We then have something which is a qualifying child. Now, a qualifying child is not entitled to full care leaver rights, but they're entitled to a different form or a lesser form of rights. It's a child who left care on or after their 16th birthday, but was looked after for less than 13 weeks after their 14th birthday, even by 1 day. They were entitled to help, but not on the same scale as care leavers. So effectively, you've got care leavers, and then you've got qualifying children. So what kind of help do care leavers get? Could I have slide 14, please? The kind of support they get depends on their status, basically. How do you find out what care leavers are entitled to? The first place to look when you are looking at somebody who's a care leaver, who's complaining about care leavers' rights, is you look on the local authority website. The local authority is obliged by law to publish details of its support for care leavers in something called its local offer. Now, that was introduced by something called Section 2 of the Children and Social Work Act 2017, but effectively it says in clear terms, should say in clear terms, exactly what the local authority is prepared to do, because there are differences between local authorities. And there is also national guidance, which is published as well, which you can see there. Now, there is legislation in something called the Children's Wellbeing and Schools Bill, which is currently in the House of Lords. It may become law this year. I'm not entirely sure. But what that says, this new law, it says that this local offer has to be amplified, and it has to include information to help former relevant children aged 25 to find and keep suitable accommodation, as well as helping former relevant children aged under 25 who are at risk of homelessness. So again, it will try to enhance the rights of care leavers in relation to finding accommodation. By and large, care leavers should expect their home local authority to act as their corporate parent. So it's like having your own mum and dad, except that it's a corporate mum and dad. And the support they can expect is the support that a parent would give to them. That's actually what the guidance says. So it's the kind of support that you would give to your own children. That's the general idea behind it. And there's a list there of in the notes of what the local authority is meant to do. So next slide, please, Amika. What kind of help does an eligible child get? So this is a child who hasn't actually left care as yet, but they are probably eligible to be a care leaver. So you get a social worker who visits you regularly. You get a personal advisor. So this isn't your social worker. This is a new type of social worker who is concerned with care leavers. You get a looked after care plan. You get a pathway plan, and that is a plan that guides you through your transition out of care. You have an independent reviewing officer who's somebody independent who looks at your case and decides whether the local authority is doing the right thing. It includes consulting with the child just before they leave care final review of their plan. And if they choose to stay in foster care after the age of 18, then arrangements should be made until they reach the age of 21. So that's the kind of help that they generally get. Could we have a next slide? Now, there's two things that we just need to talk about. One is called staying put and another is called staying close. And effectively, they are arrangements. They're enshrined in the Children Act, but staying put is where you've got a former relevant child who wants to continue to live with their local authority foster parents. And rather than being pushed out, they're allowed to live there until the age of 21. This kind of arrangement is particularly used for disabled children who have been with, say, a parent for a long time, and it just makes no sense to move them into another placement. So it's a way of lengthening the attachment that the child will have to their foster parent effectively. And it means that the local authority still has to monitor the staying put arrangement, provide advice, assistance and support, and they also have to provide financial support to the foster carer. So that's staying put. Now, there's also staying close. Now, staying close at present isn't actually enshrined in statute. The Children's Wellbeing and Schools Bill will bring it into law, but there are schemes already operating. And effectively, it's not quite like staying put, but it's a way of the local authority continuing to support certain care leavers, basically, even though they have left care. It's just a way of sort of keeping them close, as the name suggests, basically. And obviously, government provides finance to local authorities for doing this, basically. Okay, let's have the next slide. So what kind of help does a relevant child get? So a relevant child, the local authority has to keep in touch with them. They have to appoint a personal advisor, safeguard their welfare, and consult with the child, basically. Next slide, what kind of help does a former relevant child get? Again, they keep in touch, personal advisor, maintain and review a pathway plan, assist with employment, education and training, and there is a right for that former relevant child to further assistance to pursue education or training. Now, as you can see, the rights that eligible children, relevant children, and former relevant children all look rather the same, except that former relevant children, you've now got assistance with employment, education, and training. But the point is that you have to identify what category your young person or child is in before you can identify what kind of support they are meant to be getting. An awful lot of people that you'll be dealing with will, of course, be adults, and so they will be former relevant children. But essentially, these are the core duties that the local authority has to them. Okay, next slide, please, Amika. Let's look at qualifying children. So qualifying children are children who don't quite qualify as care leavers. What do they get? Well, they get advice and befriending from the local authority. They can get some financial assistance, basically. And if they're in full-time further or higher education, they can get assistance for vacation accommodation. And the Volume 3 guidance says that a qualifying child should have a plan similar to a pathway plan. So it won't be called a pathway plan, but it is a pathway plan. Okay, next slide, please, Amika. Let's talk about personal advisors and pathway plans. I mean, all the cases that tend to come to me, whenever I ask for the pathway plan, it always seems to be non-existent, or no one knows where it is, or it's been, given as dogs eaten it or something like that. But the pathway plan is pretty crucial because it actually sets out what the local authority is thinking in relation to supporting somebody. That's why it's a very important document. So a local authority has this obligation to appoint a personal advisor and create a pathway plan. And that relates to all three types of children and also qualifying children as well, although it's not called a pathway plan, basically. But effectively, it's a roadmap. And it's about undertaking a needs assessment, preparing a plan, keeping it under review, and then appointing a personal advisor. That's effectively what it means. It means somebody who's going to support the child in their transition from being in care to leaving care and beyond. Next slide, please. Okay, so these regulations here set out exactly what social workers are expected to do. So we're not talking about the pathway advisors, we're talking about the child social worker. So when a child is about to leave care, that is a crucial time because a social worker is mandated by law to carry out an assessment of where the child is, what's going to happen to them once they leave care, what kind of services and support, which is going to be crucial if the child is disabled, and ensure that the child's wishes and feelings have been ascertained, basically. And then there are rules, which we've got in the notes, about what the assessment actually has to include as well. So two key documents will be the assessment by the social worker and also the pathway plan. And then the guidance and the rules stipulate what has to be in those plans. So if you've got those and you're trying to support a young person, you can say, well, you said you'd do this, but you didn't. You said you did this, but you didn't. That's the general idea behind it. Okay. Could I have a next slide, please? So that's Regulation 39, which tells us what a local authority has to do before ceasing to look after a child. Could I have the next slide? And that includes what the assessment has to include there as well. Okay, next slide, please. That's the pathway plan, so I've set them out for you. The notes have a more comprehensive list. And the next slide, please, Amika. That's information about the person advised. And the next slide. Right, okay. So we now have something called the Care Leavers England Regulations 2010. Now, this contains the black letter law as to what it is that a local authority is expected to do. So, you can have a look. I mean, I won't go into detail as to what they say, but the objective is to improve local authority practice in providing support to care leavers. So its pathway plan offers a genuine response to each individual's needs. Okay. So next slide, please. This is assistance with education, sorry, employment education and training. What exactly does that mean? Well, I've set it out there effectively. I mean, these regulations that they put in are always very vague indeed, but and the local authority will have quite a lot of discretion as to how much money it actually is going to pay. But the idea is that if somebody is going to work, they might be able to get a contributions possibly to their expenses of maybe training, might be their expenses of going to work. It's basically to the extent that their welfare requires it, essentially. And that continues until the former relevant child reaches the age of 21. But it can go up to a child's 25th birthday if they're still in education or on a training course. Next slide, please. There's also further assistance as well. So you can apply if you're a care leaver for support with further education, and they probably won't pay. I don't know of any local authority that actually pays university fees, but they will pay a bursary basically, and then that bursary well, there is a relevant amount of £2,000 for an education course, basically. But some local authorities can be more generous than that. So if you've got somebody who's in higher education, it's very important to try to tap into that. From the 12th of June 2025, there's a bursary for eligible apprentices who are care leavers, and that's £3,000. And employers can also get funding. So next slide, please. Okay, so let's talk about housing, and this is where we've had some very recent changes. So there's a general duty on every local authority to help people who are homeless, but certain people are what we call priority need. So If your priority need, you are dealt with as a priority, for want of a better word. Now, priority need includes all sorts of people, but it includes specifically care leavers. Now, the guidance to what local authorities should do with care leavers set out in something called the Homeless Code of Guidance for Local Authorities. Now, the link is in the notes, but it's chapter 22. Now, if you have a care leaver who has a homeless problem, that's the guidance you need to read, subject to what I'm going to tell you about the changes in the law. But that's the guidance that sets out exactly what it is that a local authority is supposed to do with a care leaver. There's also something called the Joint Housing Protocols for Care Leavers Good Practice Guide, and that's been produced by the government, both the Department for Education and the Ministry of Housing, Communities and Local Governments, basically, and that also tells local authorities what they should be doing with care leavers. And then finally, there's also another set of guidance produced by Barnardo's and St Basil's, and again, that's in the notes. And that's a model that aims to help organisations that support young people in making individual journeys to leave care. So you've got three types of guidance there, all which are specifically designed to help you understand the law in relation to care leavers and homelessness and accommodation. So you can't really do any better than that. Okay, could I have the next slide, please? We now come to local connection. Now, what is local connection? Now, when a housing authority looks at a person who says, well, I'm homeless, basically, they decide whether that person has a local connection because that determines whether they can help them. So let's say you turn up in a particular borough and you don't have a local connection, then the local authority can say, well, you don't have any local connection, we can't help you, basically. Now, that's a big problem for care leavers because they're often placed in care outside their host placing local authority, and they're not able to meet local connection requirements. And that does happen quite a bit. I mean, I've had any number of cases where you've got a care leaver who has been placed outside of borough, but they've put down roots in that particular local authority. They're happy there. They don't want to have to move back to their care authority for one reason or another. But of course, the borough that they're in is saying, well, you don't actually have a local connection, basically, which is obviously a problem. Now, in September 2024, the government said, well, we're going to do away with all of that. We're going to get rid of this local exemption. Sorry, this need to establish a local exemption. Now, the actual statutory instrument, the regulation that says this, is something called, and I'll read it out, but it's there, the allocation of housing qualification criteria for victims of domestic abuse and care leavers. Victims of domestic abuse are also a priority need, by the way. England Regulations 2025, so it only applies to England. And what it says is that a local housing authority, which means a local authority, may not apply a local connection test to either an eligible child, a relevant child, or a former relevant child aged under 25. Now, when is that going to come into force? The 10th of July, 2025. That is when it will become law. I mean, it may be that local authorities are already operating that, because I think the government has actually written to local authorities saying this is what we intend to do. But essentially, it abolishes the local connection test for local authorities. And right at the bottom of that slide, you can see that it applies to certain care leavers, basically. So you've got to be a care leaver for it to apply. It wouldn't apply to a it's got to be 13 weeks in care since the age of 14, or at least one day of which was since reaching the age of 13, basically. However, a local authority can exempt all care leavers if they wish, and some may well do that. So an important change there for care leavers who are homeless. Now, could I have the next slide? Now, there's another piece of legislation which is in the pipeline, and this comes back to our Children's Wellbeing and Schools Bill. And one of the things that local authorities say to people is that we're not going to house you. We're not going to house you because you are intentionally homeless. It's your own bloody fault that you are homeless and we don't have to help you. Well, being intentionally homeless, I mean, there's a lot of grey areas around that because, I mean, you might be homeless because you've got some psychotic person in the next, property or something like that who's threatening to kill you. That's not being intentionally homeless. But what this says is that the government is going to bring in legislation, so it's not in force yet, but it's legislation which will ensure that young care leavers within the scope of a local authority's corporate parenting duty cannot be considered intentionally homeless. So I think that will also be a big improvement as well. Okay, could I have the next slide, please? Now, we're going to talk about disabled care leavers. Now, we're a little bit short of time, so I'm going to have to whiz through this, but disabled care leavers are particularly vulnerable, and the reason for that is that when they make a transition, they will most certainly be receiving support either from the NHS or from the local authority, and it will be specialist support. So what will happen is that once they become adults, they come under a different act. So as long as they're 18, as long as they're below the 18, they are children, and therefore they are covered under the Children Act. But as soon as they move outside 18, as soon as they're past 18, they come under a completely different statute, which is known as the Care Act 2014. Now, that doesn't mean to say that they're not entitled to support, but the problem is that they pass to a different team. And that's when things go horribly wrong. Because what will happen is that there will be a transition. The child may be out of borough, out of a local authority, and then all of a sudden they're there. The local authority that we've said, what do we do with this child? Because it's no longer a child, it's now an adult, but there's been no provision made for that child to continue receiving the same care. And of course, if they're in a residential home, they're happy there, they're getting the support. The last thing that anybody wants is to move them from there simply because they have passed 18. So the statutes are all designed to stop this from happening. Unfortunately, they don't always succeed, but that is the general idea, is that there will be a seamless transition between childhood and adult if you are disabled, basically. So you can see where the guidance is. Could we have the next slide, please? Sorry, if you could go back to the slide beforehand, actually. That's great. Okay, yeah. So the common issues are that they require support from a number of different agencies, basically. You have to remember they're a care leaver, and therefore they're entitled to support as care leaver. Some local authorities tend to forget that, or they say, well, they're disabled. Why do they need all this support? That's for non-disabled care leavers. Well, that's complete and utter nonsense. They are entitled to the same care leaver support as anybody else, basically. And they will have complex, support packages, basically. So you've got the guidance from the Children Act. Staying put, which we looked at beforehand, is very important. So if they can stay with a foster carer, that is going to be enormously helpful. There's also something called shared lives, which was formerly known as adult placement, but it's known as an alternative to supported living for disabled people. So there are other arrangements that local authorities can use to ensure that somebody stays where they are. The actual statutes, the Care Act and the Care Act guidance, talks about how the transition is to be managed. And again, the idea is that you don't fall between the cracks, basically. In the notes, you can see quite a lot of detail, effectively. And we also talk in the notes about making the transition from children to adult NHS care. So where you've got somebody who's in the care of the NHS, the guidance deals specifically with that particular problem. And also remember the local offer, because the local offer will always set out not only the care or the support that they will offer to care leavers, but also to disabled care leavers as well. Okay, could I have the next slide, please, Amika? We're going to talk very briefly now about young migrants. So young migrants fall into a number of different categories. There's unaccompanied asylum-seeking children, victims of trafficking, undocumented migrants, and then you get some EU and European Economic Area nationals as well. Now, they will have a variety of immigration status. So it'll be refugee, they might be entitled to humanitarian protection, they might be victims of modern slavery, they might be looking to get British citizenship, whatever it may be. Now, immigration is a very complex subject, and when you're dealing with an immigration situation, you have to take advice from a qualified practitioner. And certainly I'm not one. But by and large, where you have a child that comes into the UK and they have no parents with them, generally speaking, they are going to be taken into care. That's what happens. And so eventually they will become care leavers. Now, whilst they're in care, the local authority will have a specific duty towards them. So Section 11 of the Children Act 2004 puts a duty on specified public bodies, not just local authorities, to look after these children. The Home Office itself that deals with immigration has a particular duty to look after them as well. And there's statutory guidance, basically, which is issued by the Department for Education, which you'll find in the notes, which will tell you what those duties are. You've got different categories of migrant children. And I won't go into that in too much detail, but I'll just say briefly, as we're near the end of our unaccompanied asylum-seeking children, they're people under the age of 18 who are in the UK and have applied for asylum in their own right, effectively. So they are going to be looked after children. So that's UASC children. You've then got child victims of trafficking and modern slavery. So these are people who the suspicion is that they've been brought over in order to be put to work. If there's any suspicion that that is the case, that they are a victim of slavery or modern or trafficking, then you have to follow a safeguarding process by informing the local authority, basically. And the Department for Education has produced revised statutory guidance on the care of child victims of modern slavery. And they should also inform something called the National Referral Mechanism, which is a apparatus that exists to assess the risk to these children. You then got undocumented young migrants, basically. These are people who simply turn up. They've been through the asylum process, they've not been successful, and they're referred to as appeals rights exhausted. The great danger, in my experience, for children who come to this country, either as asylum seekers or victims of modern slavery, or they may be undocumented migrants, but the great danger to them is that they may come over at, say, the age of, say, 13 or 14, and the most important thing is not just that they are supported by the local authority, because when they come over, I mean, typically many of them may come over to the beaches of Kent. What tends to happen is that they are then allocated out to different local authorities throughout the country. But the real danger for them is that their application for asylum, for British citizenship, or just their application to stay in this country, because there's a number of stages before you get to British citizenship, should be put in place as soon as possible. Now, what most local authorities do is they will be referred to a solicitor, and they should be entitled to some kind of financial support. But it's making sure that that is done before they hit the age where the Home Office will say, you don't have any right to stay in this country, because there are, of course, cases where people have not gone through that process, or the process has not been handled correctly, and they've suddenly found themselves, having been in this country for, say, 6, 7 years, all of a sudden, well, you're going to have to go back to this country or whatever, which is absolutely disastrous. So looking at that, it is a social worker's duty. The the guidance says this very clearly, but it is a social worker's duty to look at that and to make sure that they've been referred to a solicitor who can actually help them and get that process underway, because the immigration process is incredibly slow. It can take years. So it's very important that that is done. Otherwise, they find when they reach adulthood that all of a sudden they simply don't have status, or they don't have the right status, and then that has to be sorted out. And of course, it may be they can't work, they can't get NHS care, all sorts of problems can arise. So that's very much a part of leaving care. That's got to be looked at. Okay, that brings us to the end of the seminar. Thank you all very much for listening. As I say, the notes I think are either going to be sent to you or you can get them on request. But I hope that I've managed to make a little bit of sense out of something that is actually quite complex. Really, the trick is, as an advocate, is to have a rough idea of what the rights are, know where to look, and know when somebody needs to be referred to specialist help. But frequently, of course, you're in difficulty because the young person doesn't really seem to know what's going on. You've not been given any papers at all or any records, and so you've got no idea of what their rights may be. However, there are a number of cases that have come before the Ombudsman, any number of cases where care leavers have secured compensation, sometimes financial, substantial compensation from local authorities because their care leaver rights have been ignored. Or they've been able to get compensation because they should have been taken into care and they are retrospectively recognised as care leavers. Okay, so now is time for some questions. Let me just have a look and see what I've got. Okay. Let's see if I've got 3 questions here. So, yes, here we go. Can I still buy copies of Malcolm's book, Care Leavers' Rights, A Guide for Advocates? I have a copy and it is my Bible, but it is now getting a bit worn. Right. Okay. The answer is, Tracy, yes, I still have a few copies. And if you want to send me your address, I will send you a copy. I will send you another copy. If you don't mind paying another 10 quid, but yes, you can still get another copy and we still have them. I missed the name of the guidance that Malcolm just mentioned. Well, if you look at the notes that we've got, then you'll see the guidance, because I've set out the actual links to the guidance. Also, all the guidance I have referred to, and the guidance referred to in the notes is all set out with the link. Are care leavers due support, even if not in education or training? Well, yes, there are circumstances where they may well be. I mean, as we've seen now, if they're homeless, they're still entitled to some homeless support. In relation to whether they get other types of support after the age of 21, I would have to look back. I mean, it's so complex, basically. I'd actually have to look back and say in what circumstances they are. But I think there are other circumstances where, yes, they are entitled to support after the age of 21. But again, the way to look at it is look at what you've got, ascertain what category they're in. Are they eligible, relevant, former relevant child, basically, and then just follow the guidance from them, which will tell you what they're entitled to. Best to start off with the local offer, because a local offer will effectively tell you, but then you can double check that against the national guidance, basically, on care. How do you go about gaining retrospective care leaver status? Do you have to go through judicial review process, or can an advocate write a letter to a local authority? You don't have to go through judicial review. Well, let me explain what judicial review means. Judicial review is a legal process. You begin the process of judicial review by writing what's known as a letter before action. So you send the letter of action before action to the local authority, and then the local authority then respond to that letter, and then they decide what they're going to do. Now, the local authority may say, yes, hands up, that person is a care leaver, and I've seen it happen. But if the local authority say nothing doing, then the next stage is to issue proceedings. And that means court proceedings, and then a court will decide whether that person should have been a care leaver or not. However, I think your question was, can an advocate write a letter to the local authority? I think it's a very bad idea. If you think that somebody's got retrospective care leave status, you need to go to a solicitor. And the reason for that is that there is a very unpleasant time limit in judicial review, which I have to say I don't fully understand, but put it like this, it's as soon as possible. If you miss that time limit, effectively you lose your rights. So you need to go to a specialist solicitor. And there are any number of solicitors there's any number of charities who have links to solicitors who can do these sorts of cases. You need to go to a specialist solicitor, set out to that solicitor what the circumstances of the case do. Because if you do that, the solicitor is more likely to be able to say whether they can do something. And then if the solicitor will take it on, and they may well take it on, there may even be legal aid available, then they will be able to take the action. But I wouldn't advise an advocate try and do it themselves, because it is a legal process and it's under a very strict time limits. Just to say, somebody said, I successfully challenged the local authority. The young person was given retrospective care thanks to your support. Okay, well, that's somebody, I'm very glad to hear that. But again, what I would say is best if it's done by a specialist solicitor. Someone else writes, regarding the exemption for care leavers to the local connection test, it was my understanding this applies to social housing allocation policies, not the homelessness duty, where they still need to have lived in the area for 2 years before being recognised as being priority need. Well, the answer to that is you need to look at the statutory instrument, but I actually quoted from the if you look at the statutory instrument on the local connection, there's an explanatory note to it, and I actually quoted from that. And the explanatory note explains what it is trying to do, but it wasn't my understanding that that applies to social housing allocation policies. The actual regulations are actually quite simple, and I don't remember seeing anything about social housing allocation policies. As I say, what I would do is get hold of the notes, read the statutory instrument, and then I think there is a link to some guidance. But if you're looking at a statutory instrument, you need to look at the explanatory notes. And the explanatory notes is a sort of like a guide to the law, and it tells you what the statutory instrument is meant to be doing. So that's my take on that. I have a slightly complex question, so doing my best to articulate what I'm trying to ask. Apologies if unclear. Regarding the upcoming exemption, my understanding is it refers to the eligibility for homeless support, which Homeless Code of Guidance said should be 6 out of 12 months out of 3 years. But social housing allocation is also usually dependent on meeting habitual residence requirement. So all this upcoming change mean that care leavers are exempt from local connection for homeless and habitual residents. Well, regrettably, I am not a housing solicitor, but I think the answer to that is the same as my answer beforehand. This new law has been brought in. I'll just find it again. It's been brought in by a statutory instrument, which means regulation. Yeah. And if I can just find it again. When it was announced, this is what the government said. The government announced that care leavers up to 25 would be exempted from the need to have a local connection with an area to access social housing. The government said that it had written to councils to ask them to prioritise certain care leavers and domestic abuse survivors for social housing, and that it would bring forward regulations enacting the change in due course. And then on the 19th of June 2025, the government announced that the new rules would come into force in July 2025. And in their press release, the government said, this is what the government says, there's a press release from the government. Let me just open this up a little more because I can't quite see it at present. Under the new rules, care leavers under the age of 25 and domestic abuse survivors will no longer be unfairly penalised for not having a local connection, recognising the unique challenges they can face, such as transitioning out of care or fleeing an unsafe home to seek safety. So the statutory instrument is set out, and it's Regulation 23B, and it provides that a local housing authority may not apply a local connection test to either an eligible child, a relevant child, or a former relevant child aged under 25, basically. And then I quoted from the explanation, exemption applies only to those care leavers who spent at least 13 weeks in care since the age of 14, at least one day of which was since reaching the age of 16. That is because it is those care leavers who will be sufficiently disadvantaged by a local connection requirement. It is, however, open to local housing authorities to exempt all care leavers. The exemption will no longer apply once a person loses their care leaver status at age 25, but it is open to housing authorities to continue to apply an exemption should they wish to do so. I haven't, because this is so recent, I haven't been able to find any guidance on it. But anyway, my point is this, is that reading the statute, it seems to be fairly straightforward. So again, I'm not sure that I'm not sure where social housing allocation rules or habitual residence rules would come in there. What I'll do is I'll take another look at the statutory instrument, but I did read it and last week or this week actually, and that wasn't something that jumped out at me. So I'm not entirely sure whether that will apply or not. As I say, it's always best to go to the original law when it comes in. When it does come out, there will probably be something in the Community Care magazine, which is free to look at, which will be commenting on it. Anyway, I think that's it. I'm not sure there's any further questions at this time. So thank you very much indeed, everyone, for listening. If you have any further questions, please don't hesitate to ask. Our free surgery for organizations takes place on the first Friday of each month. If you're not an organization which is part of that, you can always email me and ask, well, can we be part of that? And you're always very welcome. I'm always happy to answer questions from advocates at other times. There's a final question here from Tracy. I will pay the £10. Do I do this via Amica? No, send me an email, please, Tracy, and then I will, what I'll do is with your address, and then I will make sure the book goes to your address, but I'll have to send it through my work, is the answer to that. Okay, great. And someone else has just emailed me for the book. So I am now £20 richer. Whoopee-doo. Excellent. Wonderful. Okay, well, thank you very much indeed for attending, and the best of luck with your care leavers.